Okay. Hello, everybody, and welcome. Thank you for joining us. And what we're going to cover today, Roy and I, we call it alphabet soup. And the reason for that is because there are a variety of different laws that can come into play all at the same time with regard to one employee situation. So it's very important to look at each law separately in a particular case involving a particular employee to determine what your obligations are and kind of stay away from, having blinders on and saying, okay, this is an FMLA situation. And sometimes it may well be an FMLA situation, but the ADA and workers' compensation can also come into play, as can OSHA. And I'm going to spend just a tiny bit of time on OSHA, and specifically when COVID-19 cases can be something that in the workplace that has to be recorded on an employer's OSHA 300 log. So because COVID-19 is kind of the newest challenge in this area, I'm going to start by kind of talking specifically about COVID-19 and how that impacts an employer's obligations. And then Roy is going to give a very, very good sort of primer on each of the laws and how they interact. So this flow chart that we have here is sort of a template, sort of an overall analysis that you can use. So when an employee has an injury or illness, you kind of have your two sides. Was it not on the job? Okay, it's great. It wasn't on the job. The only thing that's going to come into play is coverage under a group health plan, medical treatment. If it's on the job, you have workers' compensation, and that's what you pay your workers' compensation premiums for, so that they can cover lost wages and medical. Then we go down to the next part in this sort of flow chart, which is it a serious medical condition or a serious health condition? If not, we have our route to the left. It's not the person cut their finger at work and had to have 3 or 4 stitches and they're A-okay. So now we just move down and don't need to worry about anything else. But if it is a serious medical condition, it may be covered by FMLA. If there's a doctor's certification that it is a serious health condition, Fmla will come into play. Then after that, if the individual is done with their FMLA leave and they can come to work, they're fit for duty at the end of the 12 weeks, oh, they're perfectly fine. They're going to return to work. On our left side of the flow chart, on the right side, we have no, the person is not fit for duty. They have perhaps something that's going to qualify under the Americans with Disabilities Act as a disability under the ADA. And then we go down in our flow chart to, we potentially have to provide that person with an accommodation over and above the FMLA leave, and or not, there is not an accommodation that we can grant. So the presentation we're going to do is going to cover sort of all of those and how they interact with each other. Oh, and one thing on the prior slide I wanted to just real quickly mention that may be applicable to some employers, which is the ADA is going to apply, the FMLA, applies if there's 50 or more employees. But the ADA comes into play if 15 or more employees. But an important part to remember about that is even if an employer is small enough that the ADA doesn't apply, if there's 6 employees, 7 employees, you also, not necessarily covered in this presentation, but you also need to consider your state non-discrimination law. For example, the Missouri Human Rights Act applies if an employer has 6 or more employees, and the coverage or the requirements of the Missouri Human Rights Act with regard to an employee who has a disability or handicap, pretty much similar to what the ADA requires. So the basic protections of each law, and Roy will go into these in more detail. FMLA, up to 12 weeks of job protected leave, a prohibition on discrimination or retaliation. The ADA, you can't discriminate against individuals who have a disability, and also must engage in the interactive process for an employee with a disability who needs an accommodation. And I'm going to cover that. Workers' compensation, the easiest perhaps, provides compensation for injured employees at work. And while the workers' compensation laws of each state, with I believe the exception of California, but in each state don't mandate that an employee be returned to the same job if he or she is off for a significant period of time outside of Fmla, say 6 months. However, the laws are clear in every state that I'm aware of that you can't retaliate against an individual for having exercised their rights under their workers' compensation law. And that they usually are reinstated to the same job. The ADA prohibits discrimination based on disability. However, the individual must have the ability to perform the essential functions of their position, either with or without a reasonable accommodation. It of course applies to all terms and conditions of employment. The one thing that sort of is an overlooked obligation or something that isn't really emphasized a lot is that at the applicant stage, so applicants for employment also are covered under the ADA. And just sort of a simple example of that is, for example, if you have an applicant who has a hearing impairment who indicates they need an interpreter to be present at the job interview, that is something that the employer would have to provide. That's sort of something that is overlooked every once in a while, but it doesn't come up a lot really. So that the ADA's actual has the three-pronged approach. Most often what we see and what we talk about and kind of counsel clients through is when a person actually does have a disability, a physical or mental impairment that substantially limits a major life activity. And I'll talk about what those are. This is what we encounter most commonly. However, a person having a record of a disability, somebody who had cancer 5 years ago, fully recovered, that person has a record of a disability, regarded as having a disability, is also something that is protected. So the regarded as can kind of come up in a number of different ways. Just a quick example of that would be, when you're interviewing during the pre-employment process, of course, you're not going to ask an applicant for employment, hey, do you have any medical conditions or anything like that? You're not going to do that because everyone knows you can't ask medical questions pre-employment. However, a candidate could potentially volunteer medical information. For example, if the employer during the pre-employment process tells the applicant, I want to let you know, we do test for drugs here, and we have a zero tolerance policy for any illegal drugs, and the applicant volunteers, oh, well, I need to let you know, I just need to let you know that I use medical marijuana, that I have a medical condition, and I use that. And so that if the applicant sort of blurts that out there, you can't unknow that information. The person then has essentially told you that they have a medical condition that could be a disability, and that's why they have their medical marijuana. So if that applicant is not ultimately hired, the employer may have great reasons for not choosing that applicant unrelated to the medical condition that they use marijuana for. However, the person could potentially say, oh, I think I was not hired because I disclosed this medical condition. So that's how that can come up sometimes. The ADA, qualified individuals with disabilities, can't be discriminated against in any aspect of employment, no retaliation. Reasonable accommodations have to be provided unless it imposes an undue hardship, with an undue hardship meaning significant difficulty or expense. And in analyzing that, what is undue hardship? What is significant difficulty or expense? Court would always look at a lot of different factors, one of them being essentially how deep are the pockets of this employer. As an example, many years ago, we represented a very, very small nonprofit that provided adult daycare services in a small town in Illinois. And one of the employees' job requirements was to drive a small bus to take the participants various places during the day, shopping, a movie, medical appointments, different things like that. And that employee ended up being diagnosed with MS and needed a specially equipped van to drive the people around. I believe it had hand controls, I'm not sure, but the van cost $50,000. And she wanted that organization to pay the $50,000 for this special van. And that went before the Illinois Human Rights Commission, and the commission agreed with the employer that was an undue hardship because they didn't have the money to provide a $50,000 van. And if you compare that with a very, very large multi-million-dollar corporation in that exact same situation, the court may find that it is reasonable for a very large organization with more money to provide that. So that's kind of one of the things. Now, moving on to the physical or mental impairment has to limit a major life activity and satisfy the skills, experience, so on and so forth, and be able to perform the essential functions of the job with or without reasonable accommodations. With COVID-19, an issue that has come up that you really want to be sensitive to is if many employers allowed, say, all of their office employees to work remotely during COVID, and now are saying, okay, everybody needs to be back in the office March 1st, April 1st, whatever it was. And they have employees now bringing in notes, providing them with notes from their healthcare providers saying the individual has a significant medical condition and needs to continue working from home. And it makes it very hard for an employer in that situation to say it's not reasonable for this employee to work from home. She has to come in the office just like everybody else. If the individual says, well, no, I've been working from home for the last year and a half, and you haven't said there's any issue with my job performance. I've been doing a fine job, so this should still be a reasonable accommodation. So that with COVID-19, that's a very difficult issue that employers are facing, because it makes it difficult for them to argue it's not reasonable for this employee to continue working from home when she's been doing it for he's been doing it for the last couple of years. So the major life activities, all of the things that you see here, I'm not going to go through every one of them. They're all of the really important things, and also include the operation of major bodily functions like immune system, respiratory, circulatory, digestive. And that's kind of what's going to come into play a lot with people who have long COVID. And I'm going to talk about that because that's the issue with COVID-19. So COVID-19, does an employee's bout with COVID-19 qualify as a disability? Well, it depends. Many people that have COVID-19 or have had COVID-19 simply had a week of not feeling very well, or perhaps even tested positive and had not one symptom at all, and were completely shocked when that individual found out that they were positive. So those individuals are not going to be in a situation where their particular bout with COVID-19 is a disability. However, if a particular employee's COVID-19 does fall under the general ADA definition of disability, then all of our standard ADA analysis and requirements are going to apply. And the EEOC actually has updated its guidance. It's available on the EEOC's website. There's a very specific section that relates to COVID-19 and ADA, and essentially says that if it does affect one or more body systems, it substantially limits a major life activity, then it's going to fall under the ADA. So employers just have one more hurdle to get over. The EEOC guidance examples include these where an employee is diagnosed with COVID-19 and they experience these ongoing symptoms, dizziness, headaches, problems remembering or concentrating, or an individual diagnosed and gets the oxygen, but then they thereafter are substantially limited in walking and breathing. So those can be situations where ADA comes into play. And if the individual is diagnosed with actual, quote, long COVID. And there are some healthcare systems, for example, in St. Louis that I know of that actually have a facility or a part of their organization that is called the Long COVID Clinic. And I'm not sure what goes on there yet, but I assume that they're trying to help people who have these, what they call long COVID. The World Health Organization has sort of come up with this definition that you see on the screen, where the symptoms are lasting at least 3 months. There's nothing else to explain all of these symptoms aside from the COVID infection, fatigue, shortness of breath, all these things. And of course, they are going to affect the major life activities of breathing, mobility, and things along those lines. So it can be an ADA. And there are some other, quote, definitions of long COVID, but essentially it's going to be where the person having the COVID is resulting in a long-term or even a chronic / permanent medical condition that is of significance. So in some cases, there are accommodations that can be provided, but in others, there's not going to be much of anything. The other is whether the COVID-19 qualifies an individual for leave under the FMLA. And again, we fall back to FMLA, which allows individuals to have leave if they have a, quote, serious health condition, if the healthcare provider certifies it's a serious health condition, unless there's some reason that you don't believe them. That's typically pretty much the end of the inquiry. It's also possible that COVID-19 can be considered covered under workers' compensation. It's very important that you look at your state workers' compensation law, because a whole slew of states made amendments recently to the workers' compensation statutes that address COVID-19. A lot of them are pretty specific to say that if the individual works in a healthcare environment, some of them say a school environment. So these are the state COVID specific statutes related to workers' compensation. You want to just know, is this something that I need to report to my workers' compensation carrier? And this is what I was talking about, the healthcare workers, essential workers, some school workers. So you just need to really analyze whether your state is going to consider COVID to be a work-related injury or not, and notify your carrier is always pretty much the safest thing to do. So then also, as we all know, we were able to escape the OSHA emergency temporary standard that had to do with the required either vaccination of all employees or the weekly testing. So we did escape all of that through the court system. But under the OSHA general duty clause, OSHA has ramped up investigations recently. The general duty clause essentially is sort of a catch-all that requires employers to provide a place of employment free from recognized hazards that are likely to cause death or injury. While OSHA encourages vaccination of workers, of course, it's not mandated, but all these other, there are a bunch of other OSHA standards, and OSHA's going out now, which is kind of interesting because during when the COVID first began, shortly thereafter, OSHA required its investigators to work from home. So they weren't really out finding any violations, but now they're back in force. So they have stepped up enforcement. And there are other OSHA standards that are not new, that have been around for a while, that OSHA is concentrating on, such as the eye and face protection, respiratory protection, hand protection, and the bloodborne pathogens standards if you're subject to any of those. And also then OSHA did address a while ago, I don't recall exactly when it was published, but when is it that a COVID-19 case in your workplace is going to be something that has to be recorded on your OSHA 300 log? And the guidance is it makes sense that COVID-19 illness in the workplace, you have a worker who tests positive for COVID-19. And this was a lot more relevant, early on when the cases were just developing, if there was a group of workers, say like a pod of 5 workers who worked very closely together, and they all developed COVID-19, it was probably something that should have been placed on your OSHA 300 log. Excuse me. Or if an employee had a very lengthy exposure with a customer, they rode together on together in a car on a trip that was 3-4 hours long, and they both have it, okay, probably work related. But if the employee was the only one in his area to have it, and his job duties didn't include frequent contact with the general public, not work related. And the last one on here, the example that was given quite a bit, is a worker who had a spouse who perhaps worked in a nursing home or a medical facility, and the spouse tested positive for COVID. Most likely it was not something that should have been on the OSHA 300 log. And also then the benefit to employers is after the employer considers the factors, if the employer can't determine whether it's more likely than not that it happened in the workplace, they don't have to record it. In the healthcare industry, of course, it's more likely going to be considered as something that needs to be on your OSHA 300 log. And the fact that OSHA may require a particular case to be on the OSHA 300 log doesn't necessarily mean it's also compensable under the state workers' compensation law. They're not exactly the same standard. Again, you're going to have to look at your state workers' compensation law. And then OSHA did publish, effective January 15th, 2022, these new increased maximum penalty amounts for different types of violations. And I wanted to talk then just real quickly before I turn it over to Roy, the general ADA requirements. If the interactive process is the first part in the ADA process, and it's required even if you believe there is no accommodation that would allow the employee to perform the job. For example, if an employee's job entails climbing up and down a ladder constantly, that's all they do, up the ladder, down the ladder, up the ladder, down the ladder, and the employee loses the use of his or her legs, you probably, both the employee and the employer, are like, I don't understand how you're going to be able to climb up and down the stairs 80 times a day, but you still have to have that inquiry. You still have to have that interaction with the employee to determine whether there's a reasonable accommodation. That interactive process in and of itself is a requirement under the ADA. And the interactive process, it comes about if the employer knows the person has a disability that's affecting work, or the employee requests it, either way. The things to do are to, with the interactive process, talk about what the limitations are, assess the need for an accommodation, and provide something. And there is some case law, very limited case law, that indicates that that providing additional time off is not a reasonable accommodation under the ADA, because in these courts' opinions, the ADA requires reasonable accommodations, which is something that will enable the employee to do the work, not stay home from work. However, those are very limited cases and not the position of the EEOC. The EEOC would say that granting time off can be an accommodation at times. It really just can be an interactive process, discussion, series of discussions. So the sort of flow chart there with that is to recognize an accommodation request, and it does not need to be the employee saying, I have a disability under the ADA and I'd like to begin the interactive process now. Anything like that, just knowing that the employee has a limitation, getting information about the limitations or restrictions and how long they'll be in place, talking about possible accommodations, implementing it, and just kind of making sure that the accommodation that you've provided is working, that the employee is fulfilling his or her job requirements, and hopefully that all does work out. The employer responsibilities, of course, to determine if the employee is qualified. For example, if an individual applies for, has some known limitations and applies for a position as your CFO, and the requirements of that position are you have to have an accounting degree and have your CPA certification, and the individual doesn't have any of that, well, they're not qualified for the job, just the basic qualifications. Also determining whether they have a disability, and that's sometimes kind of tricky. I have a case right now where an individual is claiming to have a disability due to a particular medical condition that restricts her from driving, yet we see that she's driving every single day all over. So that's going to be a tricky one there. And then determining if a reasonable accommodation is possible. And one of the things that we always sort of, mention in policies and things like that is that the accommodation the employer provides does not need to be the particular accommodation requested by the employee. So if an employee, for example, has carpal tunnel and they're requesting that the employer provide him or her with a $5,000 special keyboard, and the employer can go and find one at Costco that does the same thing and it's $2,000, the employee, as long as it does in fact enable the person to perform their job duties, they don't get to say, well, I want the Premier, the Mercedes-Benz keyboard, because the other one does just the same thing. Employee, of course, has to perform the job, adhere to standards of conduct, and obviously you can always ask for documentation from the individual to support their need for an accommodation. Reasonable accommodations always going to be very fact specific. An employer never has to dislocate another worker. You don't have to fire somebody in order to make a position that somebody with a disability can do. Don't have to create a new job, don't have to lower productivity expectations. And some of the examples are over to the right-hand side that are just some pretty simple examples of possible accommodations. And again, here's some more examples: putting in a ramp, making facilities accessible, modified work schedules. These are all some common examples of possible accommodations. And if the employer knows the employee has a disability that affects work, the employer should take the first step to initiate the interactive process, and not say, oh, well, the employee has to fill out a specific form to request that. So, and the things that are considered in determining the undue hardship, like I talked about before, the cost of the accommodation is a big issue. And you can see the fourth bullet point talks about the overall financial resources. A very, very large organization with some additional funds is going to be expected to provide an accommodation that might cost more in a very, very small organization, perhaps can justifiably say, no, providing that is too expensive, it would create an undue hardship for us. And the type of operation is also considered. So the last thing, the kind of things to remember: recognize a potential disability, try to establishing sort of a standardized process for the interactive process, and for handling accommodations is a great idea if you have a leave administration person who is familiar not only with the ADA but also with the FMLA, and if things change, always have a continuing ongoing dialogue with the employee. Let them know they're free to bring any concerns to human resources. And now I'm going to turn it over to Roy Smith in our office, and he's going to kind of go through and remind everybody about the general requirements of each of the laws we talked about. Roy?
All right. Give me 1 second here as I share my screen. There we go. All right, so as Amy and Karen already said, my name is Roy Smith. I'm going to be going over with you just a primer on the FMLA, or the Family and Medical Leave Act. Just a little bit of general information. This act provides up to 12 weeks of unpaid leave. You get 26 weeks for military caregiver leave, and you also get the right to continue health insurance benefits with an employee paying the same premiums as active employees, and you get the right to instatement. So those are the big three things that you want to pay attention to when it comes to the FMLA, but I'm going to break it down and go into a little bit more detail with you. All right, so who's covered by the FMLA? So you have employers with 50 or more employees during 20 or more weeks of the current or preceding calendar year. That also includes public employers as well. The covered employees under this act will be employees that worked a total of 12 months. It doesn't have to be consecutive, that's very important, but they must also work at least 1,250 hours during the preceding 12 months. Now, this does not include employees that work for an employer that employs less than 50 people within a 70-mile radius of that facility that you're looking at. Now, before we go into the leave itself, one thing I want to point out is what a serious condition is under the FMLA. So under the FMLA, a serious condition would be something requiring, or an illness requiring, inpatient care in a facility or continuing treatment by a healthcare provider or professional. So you get up to 12 weeks of FMLA leave for the birth or care of a newborn. That'll be, to take care of your son or your daughter, or a child in foster care, or handling the foster care process. You also get leave for family members with serious health conditions, as I previously defined for you, or the employee's own serious health condition, which is what you see most of the time. You also have a qualifying exigency arising out of, an employee's parent, child, or spouse being called to active duty. Now, in 2008, there was an amendment to the act that allows for a family member to take care of a active duty military individual, and that'll be due to their injury or illness while on military duty. So some of the common pitfalls when it comes to the FMLA, I want to bring your attention to the bottom right corner. Failure to train managers on FMLA and ADA. Pretty much all of these common pitfalls are derived from that last point. So usually what you see in a lot of businesses is everyone at the top knows about FMLA. Everyone in management knows about the common pitfalls of FMLA, but what tends to happen is the individuals who are dealing with your employees on the regular basis, your supervisors, your managers, whether they be at a facility or a restaurant or a plant or whatever the case may be, they're not always as trained as they should be on the FMLA, which leads to some of the bigger issues that we see, such as an inconsistent treatment of employees. So you have one employee being treated one way when requesting FMLA leave, but another employee gets treated another way. Disciplining or terminating an employee for leave that would be covered under the FMLA, or for making an FMLA disclosure or request. That's a huge no-no, and that's something that you see a lot of the time, because that manager that individual is going to really doesn't know what's actually covered under the FMLA, which leads us to another common pitfall, which would be a failure to recognize a reasonable accommodation request. And we're going to go into what that means. And what you'll see as we go into those is that it doesn't have to be a complete, straightforward, I am requesting FMLA leave. It's the responsibility of the employer to train its managers and supervisors to recognize FMLA illnesses when they occur so that they can protect themselves. So employer notice requirements. So as an employer, you want to provide an Fmla poster. This should be in view of employees or applicants, I apologize. And even if you don't have employees at that specific location that would be covered under the FMLA, you're still required to have a notice available. You want to electronically post this notice as well. You should want to have a handbook, but if you don't have a handbook, you want to be sure to provide a general notice to new hires of their FMLA rights. In my opinion, it's best to have both. It's best to have a handbook that covers this, and then also provide a general notice to your new hires. You want to make sure that it's multilingual so that everyone can understand it. And you want to make sure that the eligibility notice informs the employee of the rights and responsibilities that they have under the FMLA. So what is covered under the eligibility notice? So when an employee requests an FMLA leave, or when the employer acquires knowledge that an employee's leave may be for an FMLA reason, you as the employer have to notify the employee of their eligibility to take FMLA leave within 5 business days. Now, if there's an extenuating circumstance, that's a different story. But if there's not an extenuating circumstance, you have 5 days to notify the employee of their eligibility. Now, when you're notifying an employee of their eligibility, you want to be sure to detail their rights and responsibilities under the FMLA. We're going to talk about the healthcare professional notice and things of that nature. Those are things that the employee has a responsibility for themselves. So you want to make sure that your eligibility notice, once you notify them that they have or have not been eligible for FMLA leave, that you're including what their rights and responsibilities are. Now, if an employee is not getting FMLA leave because they're not eligible, you want to detail why they're not eligible. So an example for that is they're not hitting the 1,250 hours. So you want to be sure that when you're telling them you're not eligible for FMLA, you want to make sure that it's in writing. All of this needs to be in writing, and you want to be sure that you're detailing why they're not eligible. Now, an employee notice requirement. So an employee may be required to comply with the employer's usual notice and call-in procedures. So there's nothing wrong with an employer saying, here's the number to our FMLA department or our leave department or HR. This is who you call. This is what you need to do in order to request your FMLA leave. Now, it's important to know that a failure to adhere to these rules should not deprive an employee of FMLA protections if the substance of the FMLA is given through their request. So you want to be sure that you're training your HR professionals, your supervisors and managers, who's ever managing these call-in procedures or this program that's going to facilitate giving notice, that they understand what the spirit of this act is, that they understand what the act is requiring of the employee. Because if the employee is hitting those marks, but they're not necessarily doing everything that your procedure says, they're still covered. And you want to be very careful of that. So you want to be sure that those policies that you're creating are as close to what's required under the statute as possible so that you don't run into these issues. And you want to be sure that you contact an attorney in your specific jurisdiction so that you're aware of what's required, because circuit courts have been divided on the validity and application of these employer rules. So one thing I also want to mention is intermittent FMLA leave. So intermittent FMLA leave or reduced leave schedules must be medically necessary due to a serious healthcare condition, and we've already talked about what that actually means, or a serious injury. An employee, upon request, should give the employer notice of their need for intermittent leave, and it's up to the employee and the employer to facilitate a schedule that works for both parties, and it should be approved by a healthcare professional. So we're going to move on to notice of unforeseeable leave. So as I said earlier, there's nothing wrong with an employer having a process for facilitating FMLA leave. But what you want to be careful about is not only recognizing that the employee is hitting the necessary requirements that are in the FMLA statute, but that you're also paying attention to the fact of if this leave is unforeseeable or not. Because if the leave is unforeseeable, the employee must provide notice to the employer as soon as practical under the facts and circumstances. So that's the responsibility of the employer in this situation, to dig into the facts and understand, okay, wait a minute, is this a situation where it's impromptu, it just happened, or are there circumstances and facts at play that have prevented them from following our normal process? Because if it is unforeseeable, the employee only has to notify the employer within a reasonable amount of time as soon as it's practical. So healthcare provider certification. So an employer can make a request within 5 business days from the time that the employee gives notice to provide a healthcare provider certification, just certifying that the leave that they're seeking is proper under the FMLA statute, that the illness or injury that they're complaining of is covered under the act and necessary. The leave is necessary. So one thing you want to be very careful about is doing the work for the employee. Once you give the employee the paperwork needed for the certification, the employee must submit within 15 calendar days of the request, unless it's not practical. So again, you want to be staying in contact with the employee to ensure that it's practical for them to provide this within 15 days. And if it is, they have a responsibility to provide the certification within that amount of time. Now, if the employer wants to give an extra amount of time, by all means, they can do that. But again, you want to be sure that you're treating everyone consistently and that you're having a process in place that's treating everyone in the same manner. Because again, that's one of the common pitfalls of the FMLA, is not treating everyone the same. Now, another thing I want to mention is when you have an incomplete or insufficient certification brought in by the employee. So an incomplete certification would be a certification that has one or more entries that aren't completed or blanks that are not filled, or insufficient would be that the certification is vague or unclear. The employer can give written notice to the employee that the notice is incomplete or insufficient, and then the employee has 7 calendar days to bring back a sufficient and non-vague certification. Now, as the employer, as I said earlier, you can't do the work for the employee. Obtaining the healthcare professional certification or healthcare provider certification form is the employee's responsibility. Now, the employer can contact the healthcare professional for clarification and authentication purposes, but you want to be sure that when you're doing this, you're not having a direct supervisor or manager contact the healthcare professional. You want to be sure to keep this as above that individual's working space or the environment that they're in on the regular basis as possible. You want to keep that to a company nurse or an HR professional. The clearer the standard is on who's actually calling these healthcare professionals, the better, which is why it's a good idea to have a department or a set person in place that manages your FMLA request. So also, the employer may contact for authentication and clarification purposes, but this is not a green light to ask whatever questions you want to ask. You want to keep it strictly to authentication and clarification. Those are the two things that your HR professional or your company nurse or whoever's actually calling for these purposes, you want to keep it narrow to authentication and clarification. This is not a green light to ask all of these different questions about the illness and what hypotheticals and things of that nature. You want to keep this conversation clear cut as possible to keep from creating any possible legal liability. So eventually an employee's FMLA leave will end and they have a responsibility to return to work. So as a general rule, an employee is entitled to return to the same or equivalent position that they had when they left. And as you can see in the third bullet point here, you want to be virtually identical to the duties, pay, and working conditions that they had before they left. Those are the big three. You know, in these times of COVID, things change and people go to working from home or whatever the case may be. Sometimes things change while an individual is on FMLA leave. But when they come back, the things that you want to be paying attention to are these three pieces here: the duties, pay, and working conditions. The closer you get to what those three things were before they took the leave, the better. So one of the common challenges of the FMLA is an employee mentions a serious health condition and a supervisor or manager doesn't recognize the time off as FMLA qualified, and they end up disciplining the employee or retaliating against the employee. That is unlawful. And retaliation doesn't mean that they had any ill intention towards that employee. What it means in this circumstance is that the employee requested FMLA leave, and because of that request, some form of discipline or improper treatment occurred as a result of that. That is retaliation. So you want to be careful and you want to make sure that you're training your supervisor to recognize these different serious health conditions and FMLA qualifiers. So another common pitfall and challenge that you see with the FMLA is employers who require employees to use their paid time off instead of the FMLA for FMLA qualified leave. That is not lawful. Now, if an employee would like to continue to be paid, then you can use the two concurrently. But you want to be sure that if an employee is on FMLA leave, you're not retaliating against them and you're not require them to use any other form of leave other than the FMLA leave. Now, if they want to use it concurrently, then they can do so, but you can't require that. Again, FMLA leave and no fault attendance policies. There is nothing wrong with having a no fault attendance policy in general, but you want to keep from retaliating against employees or interfering with their right to use the FMLA. So employees cannot consider FMLA leave as a negative factor in employment actions. This is lawful leave under the statute. So when you're looking at an employee, whether that be for promotions or things of that nature, you want to be sure that you're not using FMLA leave as a piece of that decision or as a factor in determining if a person's going to get promoted or a raise or a bonus of sorts. So what happens if FMLA is exhausted? Well, if the employee doesn't return to work after the expiration of their leave for a non-medical reason, the employer is free to advise the employee that they must return to work or be terminated or disciplined. And what you see a lot of times when it comes to FMLA leave is there's all these different issues for some employees that arise once it's time for them to come back to work. Some of those examples are listed here: a lack of transportation or a desire to stay home longer, or trying to figure out logistics with returning back to work. That is not the responsibility of the employer. Once the FMLA leave is exhausted, those type of things don't matter. An employee has a responsibility to return to work. Now, if the employee has not returned to work, you want to be sure that they don't have a disability as defined by the ADA, because then, as Karen mentioned earlier, reasonable accommodations will be required. So at the minimum, if you have an employee that's not returning and they're claiming that it's because they are continuing to have an illness of sorts or things of that nature, you want to be sure that you engage in the interactive process that Karen mentioned earlier to be sure that you didn't handle FMLA properly just to be found in violation of the ADA. You want to be sure that you're paying attention even after the FMLA leave is exhausted, to what the employee's needs are, because they may be required to have disability or, you know, a reasonable accommodation under the ADA. So again, keys for the employers: you want to be sure that you're using proper FMLA forms. You want to get those from an attorney. Some of those are also available with the Department of Labor. You want to require employees to provide notice. And again, the biggest thing that you could possibly do to be in compliance with FMLA is to train your HR managers and supervisors on the FMLA, because then that'll lead to you having consistent application and keeping proper records. Now, the FMLA prohibits retaliation against employees for exercising their rights. But as long as the employer has an honest belief that FMLA is being misused, you can defeat a retaliation claim. And you're not required to be absolutely certain, but you must be sure that you're investigating these occurrences with good faith. You don't want to go into an investigation of an honest belief defense or a misuse of FMLA leave by an employee with preconceived notions, because what ends up happening is employers usually are found lawful when they're going into these situations looking to confirm their preconceived notions instead of actually getting all the facts and determining if an employee misused their FMLA leave. And you see this in the Dunger v. Pacific Railroad Company case. In this case, the boss of an individual saw a video showing that an employee who took intermittent FMLA leave literally took a fishing trip. And they terminated the employee sued, and the court ruled in favor of the employer because they had an honest faith belief. They investigated this claim properly. They saw the video showing that he was on a fishing trip, and they terminated him. They were able to use the honest belief defense to defeat a retaliation claim. Now, you want to be careful in those instances also, because if an employee is required to rest and relax in order to cure their illness or deal with their illness, whatever that employee needs to do to rest and relax is lawful under the FMLA. And there have been cases where employers have been fined and found in violation of the FMLA because they thought that they were pursuing an honest belief defense when in reality, they were retaliating against an employee for doing what they needed to do to rest and relax. And again, so the ADA covers disability, and you want to give a reasonable accommodation for those. The FMLA is an illness-derived leave, and you want to be sure that if an employee exhausts their FMLA, you're paying attention to what their illness is and what their needs are, because they may be required to have a reasonable accommodation for a disability under the ADA. Now, workers' compensation is essentially receiving leave and compensation for an injury that occurred at the workplace. And just like the FMLA and ADA, an employer can't retaliate against an employee for using workers' compensation. And the easiest way to ensure that you're complying with your state's workers' compensation laws is to ensure that an employee who's off work due to work-related injury receives at least the same consideration or accommodations as the employee who has missed work for a non-related injury. So again, we're going back to this general concept of treating everyone equally and treating individuals who use leave the same as individuals who did not use leave. And with that, I'm going to turn it back over to Karen if there's any questions that you all have submitted in the Q&A.
Thank you so much, Roy. I'm just going to step in here real quick. I think we have a couple of questions. I just want to clarify before we get to all the questions. Just want to clarify. There were a couple of questions saying the employer. Can you clarify that the employer can't make the employee use their vacation or sick leave along with the FMLA hours along with their FMLA?
Yes, they can't require it, but if an employee wants to use it concurrently to continue to be paid, then that's absolutely okay. But you can't require an employee to do that, and you can't require an employee to use PTO instead of FMLA leave. if they have the right to use FMLA leave, then essentially, if it's lawful, there's nothing the employer can do to stop them from using that leave.
If I can just clarify, if you can hear me, just clarify further, I guess, to what Roy's point was, is if I am the employee who's entitled to FMLA, the employer certainly can have an FMLA policy that says, while I, employee, am on FMLA, I must first exhaust my paid vacation, my paid sick time before my FMLA leave continues on an unpaid basis. So what Roy's point was in the presentation is if the employee is eligible for FMLA today, the employer cannot say, oh, Karen, I see you have 2 weeks of vacation here, so you're going to have to take those 2 weeks of vacation first, and then we'll start your 12 weeks of FMLA. So just, you absolutely can have a policy that says, while on FMLA, we're first going to require exhaustion of paid time off before the leave continues on an unpaid basis. So hopefully that covered that.
Okay, awesome. Thank you guys so much for clarifying. So I know we only have a couple minutes until 1. I want to let everybody know before we start answering these questions, because I'm sure a lot of people will have to log off. I will email everybody a copy of this webinar that's being recorded right now. I will also include the slides from Karen and Roy so that you can follow along with that. You'll also receive a free digital FMLA and ADA book. So that email will be coming to you all tomorrow. And if you have any questions in the meantime or anything pops up, you can always email me or Karen or Roy. Their email addresses are right here up on the screen. I will also email you all the credits, the HRCI and SHRM credits. So now, Karen and Roy, you guys can get to any questions that you have time for. And then the rest we will try to answer in a written form, and I'll just include that in the email because we have quite a few here. Awesome. Thank you guys.
Oh, do you want me to go ahead and answer some of them that are in the Q&A queue?
That would be great. Thank you, Karen.
The first question I see is, does asking an applicant if they're a smoker fall into asking medical information? That in and of itself does not. However, I want everybody to be aware that in some states, such as Illinois, an employer cannot take adverse action against an applicant and an employee because of that person's lawful off-duty use of a lawful product off-duty, such as in Illinois, marijuana. And that's why if an employer just in a smoke or cigarettes would be the same answer. So you want to be careful of that. But the asking them if they smoke or not from an ADA perspective, that's not medical information. That's a habit, if you want to put it that way. And then the next question I see is, if an employee takes the vaccine, COVID-19 vaccine, and is injured, is that considered a disability? Once again, we go back to our basic analysis of the definition of disability, that it has to be something that limits one or more major life activities. So if the person does take the vaccine and they get this horrible reaction, their liver shuts down or something, very significant takes place, if that taking the vaccine does result in a disability, it certainly is possible. It's covered by the ADA, but that's going to be sort of a fact-specific inquiry. Let's see. The next question I see is kind of a longer one. So I'm going to kind of move down.
If you want to move down to the shorter ones, and then we can answer the longer ones in a written format, that's totally fine, Karen.
Okay. Okay, and a simple question, updating job duties, job description that was approved 20 years ago for a specific position. Now we have more details, or the position has changed. How do we introduce an updated job description? As long as the job description is an accurate representation of the job duties, you can do that at any time and say this is effective April 1st, 2022. And a good way to introduce a revised job description like that really is to have the employees who are doing the job, quote, buy into it. In other words, have them look at what you've written and show it to these 5 people who have this job and say, does that look pretty much accurate to you? And to get kind of input from them about that. let's see. Next question is the 50 or more under the FMLA to be covered, an employer has to have 50 or more employees for 20 or more calendar weeks during the current or preceding calendar year. And the question is whether that's with a legal entity only, and it's actually the employer. In other words, if I am a sole proprietor that owns Karen's fabrics or whatever, I can be a sole proprietor. If I have 50 or more employees, doesn't really matter as to whether the actual employer is a corporation, an LLC, a sole proprietor. If that entity in fact is paying the employees, they're getting their wages, their W-2s, et cetera, and I'm directing their work, then the entity would be covered under the FMLA. Let's see. Okay, a quick one. This is a good one. Doctor says they should be allowed to work remotely. We've had a lot of this lately. Do we have to abide by that if we can accommodate them at the workplace? So, and I know employees get doctors to write anything. So the issue, it's going to, if the doctor says the person should be allowed remotely, but the employer thinks that whatever that specific restriction is, that the doctor is saying that Karen should work remotely, the employer can accommodate whatever it is I need in the workplace. For example, if the doctor says Karen should be allowed to work remotely because she has an eyesight issue and a disease, and she needs to be working in a room that's dark. So the employer comes forward and says, hey, we have it, this room down the hall, we'll put your computer in there, we can make it completely dark, it's going to accomplish the same thing. And that's perfectly fine if the person is getting the accommodation, which is required simply to work in the dark at the workplace. That's fantastic. Most of the time, the specific information provided by the doctor is going to create a situation where it's not that simple. And so you have to take that into consideration. Roy, did you want to take a few of them? I don't know if you're seeing them.
I can't really pull it up for some reason.
It's the bottom of your screen if you see Q&A. And I think we already answered the couple of questions about vacation or sick leave, PTO, et cetera, on FMLA. You can do that, but they would be, if your policy says you have to exhaust available vacation and sick before your Fmla continues on an unpaid basis. We already kind of went over that, but.
Yeah, that was the one I wanted to clarify, but you clarified that one already.
And then I guess a couple others here. What obligation the employer has with regard to workers' compensation, absences, if an employee fails to return to work and fails to return phone calls from the employer. Oh, it would be great if you had a provision in your employee handbook that says, for example, 3 days, no call, no show constitutes a voluntary resignation / abandonment of the position. And then if the employee is fully released by the workers' compensation carrier, and you have that documentation that says Karen is fully released to return to work effective April 10th, and I don't come to work, and the employer then calls and says, essentially, you've been released. We have the documentation to show you've been released. You need to return our call or show up for work. And if you would have a 3-day no call, no show policy, and you're definitely calling the right number, and then send them a letter that says, our policy is 3 days no call, no show is a voluntary resignation under Section F of the employee handbook. You were fully released on this date. You were scheduled to work. We called you. You didn't return calls. As long as that's something that the employer can show is consistently enforced, it should be okay. And some of the